the ATF's arm brace ruling and what it means in application to the firearms platform others. Welcome to another installment of Connecticut Gun Bench. Today's video is brought to you by P.A.N. Firearms, LLC, P.A.N. Firearms for your NRA certification and multifaceted gun training. You can reach us at 203-300-6343 or use our website at www.PANfirearmsllc.com. As always, there'll be a link in the description box below. And let's talk about this. Now, I'm bringing up this subject because several people in the comment sections of videos that I've made have asked me to discuss the ATF's arm brace ruling and what it means, more specifically to Connecticut, as we have the platform others, which are very prevalent in the state since the passing of SB 1160 and basically the banning of semi-automatic assault weapon platforms. What I'm going to give you is not a legal opinion. This is my opinion, and it's based on what I read. It is based on the attitude of our government and legislative bodies, and more importantly, the attitude of our re-elected governor and his attorney general. So you have to keep that in mind as I explain this. It's not so much what we could, surmise from this. It's what is written, and once again, the attitude of our leadership. Now, we know this arm brace rule is coming into effect, and a lot of people, especially in the state of Connecticut, are saying, well, I've heard people say others don't really fall under this because they tend to focus on the fact that it's a pistol that then has the arm brace attached to it. I want to go a little bit further because you have to understand the wording of what the ATF put out. I'm going to put that up now. This is the ATF from the ATF's page, and this is the part I want to focus on here. Okay, right here, I'll go right here. The proposed rule would amend the definition of rifle in 27 CFR 478.11 and 479.1 respectively by adding a sentence at the end of each definition to clarify that the term rifle includes any weapon with a rifle barrel and equipped with an attached stabilizing brace that has the objective design features and characteristics that indicate that the firearm is designed to be fired from the shoulder. Okay, that's the ATF's wording. We can sing and dance around that all we can, but that's what an other is in all actuality. It is a firearm with a rifled barrel. We can't argue that. But, okay, I'm coming over here. And this is where the ATF was putting out their initial ruling. You want to call it their rough draft. And I come down to here. ATF's long-standing and publicly known position is that a firearm does not evade classification under the NFA merely because the firearm is configured with the device marked as a stabilizing brace or arm brace. When a purported stabilizing brace and an attached weapon's objective design features indicate that the weapon is actually designed and intended to be fired from the shoulder, such weapon may fall within the scope of the NFA, requiring registration and payment of tax. Accordingly, ATF must evaluate on a case-by-case basis whether a particular firearm configured with a stabilizing brace bears the objective features of a firearm designed and intended to be fired from the shoulder and is that subject to the NFA. The use of purported stabilizing braces cannot be a tool to circumvent the NFA or the GCA and the prohibition on the unregistered possession of short-barreled rifles. They couldn't make their language any more clearer. They're basically saying, yes, these stabilizing braces can be fired from the shoulder, used to be fired from the shoulder, and we are saying that they do fall under the NFA or GCA. Okay, now, once again, this isn't just an opinion based on what I am reading. They also put out this form, is a 4999, which is what you use to submit you submit it with, you actually have to submit pictures of your item, and you submit this form. And if you haven't read this form, I think it's up behind me here somewhere. If you haven't read this form, you need to look at this form, because this form is basically a catch-all. Basically, the way it's written and the way they set it up, anything with a stabilizing brace is not going to pass the muster for them. It is clear as day on this form. I'll leave it in the description box so you can read it. So, what are our options as residents of those of us who own others, which is mostly Connecticut and a few other states? But these are, in my opinion, are the two options that will work for us here in Connecticut. And I'll once again put this up for you. In order to comply with the provisions of the NFA current unlicensed possessors, which is everybody, of a firearm equipped with a stabilizing brace and a barrel length of less than 16 inches that would qualify as a short barrel rifle as indicated on the ATF worksheet 4999, which you saw contained this proposal rule, would need to take one of the following actions before the effective date of final rule. 1. Permanently remove or alter the stabilizing brace such that it cannot be reattached, thus converting the firearm back to its original pistol configuration, as long as it was originally configured without a stock and as a pistol, and thereby removing it from regulation as a firearm under the NFA. Exercising this option would mean the pistol would no longer be equipped with the stabilizing brace within the meaning of the proposed rule. Yes, you hear the language there. They keep saying pistol, pistol, pistol. It refers it back to its original pistol configuration. It's a good argument, but remember what I said in the beginning. The ATF is saying any firearm that has a barrel shorter than 16 inches and is a rifle barrel. Okay, and then remove the short barrel and attach a 16-inch barrel or longer barrel to the firearm, thus remove it from the provisions of the NFA. Those two are, in my opinion, are the two strongest things you can do to circumvent this arm brace rule. So if you're going to go out and buy one with 16-inch barrel, technically you should be covered. But we're dealing with the state of Connecticut. That's the part I want to keep bringing up. So we cannot register our others as SBRs in Connecticut. I can't speak for other states, because in Connecticut, the only way you can actually make an SBR is to have a firearm that was registered as an assault weapon in 2013. And that's basically impossible for others because a majority of them were purchased after that date. So you got to remember, and why am I bringing this up? I kind of taken this road of caution because of who we are dealing with at the state level. Remember, this is the same governor who said this.
And that's not good enough. I've just been shocked over this last couple years. We have more damn guns in the street than ever before in this state right now. We have more legal guns, we have more illegal guns. As your dicks say, they're coming in from out of state. And more guns on the street, more guns in the home means more gun violence, and we're suffering from that gun violence.
And there it is. He is letting you know up front that he does not see or differentiate between legally purchased firearms and illegal purchased firearms. And remember, during the midterm season, when he was once again running for the seat of governor, he openly said he would have no qualms and is actually pursuing to remove all so-called assault weapons from the state of Connecticut. So you've got a governor with a very, very solid one-line opinion on these firearms. So I wanted to make that clear, and let me clarify one more time. This is not a legal opinion. This is my opinion based on what I am reading here. And once again, attaching that to the attitude of our Governor Lamont and our Attorney General Tong. Both of whom have been, especially Tong, if you've been in Connecticut long enough, you know that he has been an ardent anti-gun politician. So this ATF arm brace rule is in effect. It's not going away. There are no stays. There are no legal challenges at this point in time specifically on it. There are some going through the courts, but none of them has caused a hold on this proposal as of this time. So it is technically in effect. So as I said before, the two options I put there are the only two that I see that will make us, good with the ATF and the state as far as these stabilizing braces. Now, like I said, there are some cases going through the courts right now. We'll have to wait and see, but while we're waiting and seeing, this is in effect. And you can believe that the law enforcement, which is technically the arm of the government, is going to have no qualms in scooping these things up from people that they find them with these braces on. And then you have to go to court and spend your money to fight it while the state uses your money to defend it. Great how that works, isn't it? But let's play it straight up and let's see what happens here. But we have to take steps. We cannot fall back on the, well, I didn't know, because that doesn't work. But let me know what you think. As always, you can leave your comments in the comment section below. And as always, any statements of violence or statements that lead to violence will be removed. Please like, share, comment, subscribe. Don't forget to hit that notification bell so you're notified the next time the video goes live. I will see you on the next one. Peace.